in their effort to make an assessment of the rights and wrongs in the case. So there is this very serious problem from a public policy point of view. We also felt that the courts had developed a fairly sensible approach to these matters, whereby simply by leaning on counsel a bit, they're saying, well, do you really need to have this information brought out? In most instances, where the confidential relationship is one which the society should protect, and the facts of the case are such that the information really wouldn't add that much anyway, the judges have been saying, don't force the issue, counsel. Do you know, for example, of a single case in which a minister of religion has been required to answer a question as to what his parishioner told him in a confidential setting? Frankly, I don't. I'd be interested if any of you do. And yet we don't have a rule saying this is illegal. If you looked at the rules, you'd assume that it was possible. Similarly, in relation to forcing the doctors to answer, I think in most instances, unless it's necessary to the determination of the issues, confidential statements can be protected that way. To the extent that they aren't, probably they shouldn't be. That was the attitude of the task force. However, where the court has ordered a person to present himself before a psychiatrist or a medical practitioner and to answer questions in order to assist the court in a determination of his fitness to stand trial, there you're running into a situation where the state is in effect taking away his right of silence. Now, he can still remain silent. Obviously, that's one thing. But if he remains silent, that defeats the whole purpose of the court-ordered examination. So it was thought it was better to provide him with some form of protection so that the statements he makes to the psychiatrist in that setting cannot be used against him in a prosecution on the criminal charge. There are two exceptions to this, of course. Obviously, if you were to make this protection apply in the fitness hearing itself, you defeat the whole purpose of sending him off to the psychiatrist. So that has to be an exception. The other exception was that if he attempted to raise as a defense, the defense of insanity, then it was felt that he had essentially waived the privilege and that the statements that he'd made to the psychiatrist should be brought forward, or at least should be available to be brought forward. I think that maybe is a bit more problematic. I don't want to undermine the bill, but I must say that this is one area where I think there is certainly a question of doubt in terms of policy. And the policy decision that was taken has been taken, but this might be an area that deserves at some point some further consideration. Privileges in relation to marriage. Well, the main privilege, of course, is the marital communication privilege, which exists under Section 4, Sub 3 of the present Canada Evidence Act. It says that no husband is compellable to disclose any communication made to him by his wife during their marriage, no wife compellable to disclose any communication made to her by her husband during their marriage. Should this continue? The English have said no. Task Force actually said no as well. The feeling was that it wasn't necessary. But on the other hand, when it got to the Uniform Law Conference, the Uniform Law Conference said, well, we're not sure of that, particularly in view of the fact that we've made a change in relation to the competence and compellability of the spouse. We made the spouse a competent witness for the Crown in all cases, compellable in more cases. There is, we think, still a social value in providing a person with what I describe in the paper as a haven, where he can go and talk to somebody with a feeling that What he says there will not be reported later on if it's in a confidential setting. It should be something other than just his lawyer. Surely the marriage bond should provide that kind of a nexus, and the social gain that you'll have by providing this kind of a place where you can go and talk is greater than the minor social gains that may occur through being able to convict a person on the basis of his statements to his spouse. So that was the setting in which the decision was taken. Now, what has been done is to transfer the privilege from the hearer to the speaker. At the present time, it is the hearer who has the communication privilege. If you say something to your wife and she subsequently is called as a witness, she wants to protect you, she can. If she doesn't want to protect you, she would like to see you behind bars because you're a rotten SOB, she can blow the whistle on you insofar as what you told her. This isn't really much protection. So what we have provided under Bill S-33 is that it is the speaker who should have that protection. And that should be a protection that should last for life. It shouldn't be a protection that lasts only so long as the marriage lasts. There are obviously certain exceptions to this. For example, there is a proceeding between the spouses, or there is a proceeding involving the interests of children, or a proceeding where there is the interest of a third party, but it's really part and parcel of a proceeding between spouses, then the protection does not exist. So many times in the task force we found that there was an interrelationship between one set of findings and another, and I think that what we have here is a necessary concomitant of the new rules relating to the increased competence and increased compellability of spouses. I think that this is a promising development. The status of women were pleased with the question of competence, the way we dealt with competency and compellability, and also the question of privilege. Finally, in relation to matrimonial privileges, you have these old ones about the right not to answer questions that would tend to relate or would tend to bastardize a child or would tend to indicate adultery. I think these things must go out the window. They have no social utility in these days, and so they were duly abolished. The last privilege is, of course, the privilege in relation to Crown information. Here there was a major difference between what was recommended by the majority of the Uniform Law Conference and what appears in Bill S-33. The Uniform Law Conference took the view that there should be quite a number of areas where the ipse-dixit of the Cabinet should be conclusive. The Cabinet said, through the Attorney General, that this fell within the area of Cabinet confidence, national security, international relations, national defense, or, and this was a new one, a confidential communication by or to a law enforcement officer or authority in relation to an investigation or prosecution of an offense. All of these should be final, conclusive. The court couldn't go behind it and look at it to see whether or not the interest of the public in disclosure was greater than the interest of the public in keeping the confidential relationship protected. The Department of Justice, in the discussions before the task force, the Uniform Law Conference, had to take no part at all. The reason was that this was a matter already before Parliament. We couldn't appear to be advocating one stand in Uniform Law Conference and another one before Parliament. So we said whatever you do, you know, we have to be bound by what Parliament decides in the context of the Access to Information Bill. Finally, last summer, the Access to Information Bill, with its provisions relating to the Canada Evidence Act, there are now new sections 36, 1, 2, 3, I think it is, of the Canada Evidence Act, came out. And these basically, summarized very quickly, maintain what is the common law position, i.e. that generally the court has a right to demand production of a document or information, even though the Crown has said this is a matter that it would be contrary to the public interest to disclose. One exception to that is in relation to cabinet confidences. There, the decision was that if cabinet was going to operate properly, it couldn't be at the mercy, so to speak, of the courts. It shouldn't have to look over its shoulder and wonder, well, will this ever be disclosed? There, it's absolute privilege. In relation to matters which are injurious to international relations, national defense, or security, these are subject to disclosure by the court, but only if the decision is taken by the Chief Justice of the province or the Chief Justice of the Federal Court. In other cases, as to say, all cases not involving either cabinet confidences or national security, the matter can be decided by the trial judge. He can determine this if indeed he is a trial judge at the Superior Court level. If it arises in some other court or tribunal, then it has to be transferred to the Superior Court to be determined, and there are rules as to the amount of time within which the reference must be made and any appeal, etc. Now, one further thing about this, and that is that whereas all of the rest of the Act only applies to those matters falling within federal jurisdiction, the provisions relating to disclosure of document or of government confidences relates to proceedings falling within either federal or provincial jurisdiction. The basis of this is that really it isn't an evidentiary rule at all, but a question of executive privilege here. This is the Crown, the Queen essentially saying, I am willing to release certain things that therefore should apply whether it is a matter falling within provincial jurisdiction or federal jurisdiction. That is why you find it hived off as Part 9 of our bill, and you'll notice if you read the introduction as to the applicability, Part 9 applies in all proceedings. Well, I'm quite sure that the provinces are not going to accept that as the standard. A number of provinces have indicated that they are going to disregard that, and they would prefer to follow the recommendations of the Uniform Law Conference. So in this one area, at any rate, you're likely to have some degree of discrepancy between the federal and the provincial laws. Thank you very much.
Ladies and gentlemen, that concludes this seminar. I want to say a word of thanks to the speakers. I feel very sorry that there was such a small audience. The only consolation I can offer is the fact that the papers that my fellow speakers have prepared are excellent. I understand that the preliminary indications are that they will receive a very good reception, and they'll sell well through the Continuing Education Department of the Law Society. Secondly, that I think perhaps next fall there'll be a much greater interest in this area of the law from what Ed has said to us, and the tapes will be available for our colleagues late next fall to be rerun if there's sufficient interest indicated in the bar to hear you all again. I want to thank Heather Walker, the coordinator of the Continuing Education Department, for her help, and again, all the speakers. I think they did an excellent job as to both speaking and writing. And thank you those of you who did come.